Hello everyone and welcome to the second of our video tutorials on civil process ADR or alternative dispute resolution. In our first video on ADR, we looked at the different methods or types of ADR. In this video tutorial, we'll be looking solely at the advantages and disadvantages of each method. And it's going to be a bit of a whistle-stop tour, so you need to supplement this video with your own notes, but I will go over the key advantages and disadvantages of each with you. So if we start then with our first method, which is negotiation. If you recall, negotiation is the simplest form of ADR because this involves the parties trying to resolve their dispute directly together. Now, key advantages of that are that it is completely private. So if it's just the two of you negotiating, you don't have to worry about being embarrassed about things you've said or emails. It's all kept between the parties. So that can be advantageous. It might be that you get a quick resolution. So it might be a lot faster than court because you can negotiate immediately and get a resolution potentially immediately. As I mentioned last time, negotiation's really good because you can perhaps maintain relationships. Remember, if you sue someone in court, it's very unlikely that they're going to want to have a relationship with you in the future. So if you're a business wanting to continue to use a particular supplier, for instance, negotiation is going to be preferable than going to court because they're more likely to want to trade with you in the future. You're going to be closing that door if you sue them in court. Another advantage is that it's relatively informal. On a very basic level, you could arrange to meet someone just in a cafe. You could negotiate by text if you wanted to. So it can be quite informal and easy for the parties to do. Obviously, if you get solicitors involved, then it becomes less informal. But there are key advantages. Disadvantages then, and as I've just mentioned, sometimes parties will employ solicitors to act on their behalf, to negotiate on their behalf. And as soon as you start doing that, that can make the process very costly. We did talk last time about the fact that if solicitors are used and there's negotiation in that way, lots of cases will be settled out of court. But what I've put here as another disadvantage is that sometimes these offers to settle, are not actually agreed until the day of court. So that's wasting time, it's wasting money. So we would want the settlement to be agreed quicker than that, ideally. Another disadvantage is that people sometimes see it as a halfway house. And sometimes I think people are worried that if they negotiate, they might not get as much as if they went to court. And if a party is particularly angry, if the claimant's angry with the defendant, their natural human response might be that they want to make them suffer in a way by going to court. So they might not feel that negotiating is really getting them the closure or that they're looking for. So some advantages and disadvantages there of negotiation. Let's have a look at the next one then. So our second type or method of ADR was mediation. And if you remember, mediation is a step up, I suppose, from negotiation. And it's where the parties get a neutral third party to go as a go-between, often between the two parties, to help them resolve their dispute. And we said last time that mediation is particularly popular in family disputes. And you can imagine there, if emotions are running high between two individuals, they might not want to speak to each other directly. There might be a lot of animosity or bad feeling between them. So sometimes having a neutral third party can help them to talk, to open up those doors of communication. In terms of advantages, it's private. I mean, you have got your third party involved, but apart from that, it's a private and a confidential process. And a good thing about it is that it's voluntary. Parties are entering into it voluntarily. And that's an advantage because if you're not forced into something, hopefully you're more likely to want to make it work. It's more likely to be successful. It's quick, cost effective, accessible. Remember, at a very basic level, this could be as simple as you getting a mutual friend to help you and your friend who aren't talking come to an agreement. And a bit like with negotiation, there's a good chance that you can maintain a relationship afterwards. Because again, it's better to try and mediate with the other person rather than suing them in court. And it's based on compromise. So each side, hopefully, will get something that they want, and it's not based on a strict application of the law. And we've got a statistic here that over 80% of cases are settled at mediation. So that suggests it is a very effective method. As always, though, we've got disadvantages, and I've got some of the key ones listed down the side here. A big disadvantage is that with mediation, we say that the neutral third party or the mediator, their role is only facilitative, which means that they're not really very active. They don't generally suggest ways of solving the dispute. Most of the time, they are just acting as a go-between, passing messages on. So they're not really helping to reach a solution per se. Another disadvantage is that parties have to want to reach a compromise. So you can imagine in family disputes, if one party is very angry with the other party, they might not be willing to reach a compromise. So mediation's only going to be effective if the parties are willing to do a bit of give and take. Mediation isn't normally legally binding, so it might mean that even if you try this, it might fail and you end up in court anyway. Another disadvantage is that often, if people settle using mediation, the amounts agreed are often lower than with other settlements. And it could be potentially that a weaker party is forced into a settlement. So if one of the parties is a lot more confident, maybe aggressive with what they want, and the other party is a little bit meeker, they might come out of it not in an ideal position potentially. Although we've said a big advantage is that it's voluntary, we have seen with the introduction of MIAMS, for instance, with divorces, that it's increasingly being seen as a compulsory step. And if you force anyone to do anything, often they won't necessarily do it to the best of their ability. They might resent the fact they're being forced into it. And I've put there that they might have a half-hearted commitment. So if they're forced into it, it's less likely to be successful. Have a look then at our next method or type of ADR, conciliation, and look at the advantages and disadvantages here. So conciliation, remember, is very similar to mediation because, again, you've got a third party helping the parties to reach a solution. But this time, a conciliator plays a much more active role and will offer solutions to the parties. In terms of advantages, it is cheaper than going to court. Again, like with mediation, it's private and confidential. Yes, okay, you've got the conciliator, but they will keep the dispute confidential. And an advantage here over mediation is that, as I've said, the conciliator plays a more active role and they will suggest areas of compromise. And they might come up with ideas or solutions that the parties themselves haven't thought of. So with negotiation, if it's just the two parties, they might be limited to what they can think of to resolve it. But a conciliator can be a fresh pair of eyes that's going to come up with new ideas, ways forward. ACAS, which is the body that is used in a lot of industrial disputes, adopts a prevention rather than cure approach. So ACAS actually provides a lot of advice to employers on how they can actually avoid disputes from arising in the first place. And that's got to be a good thing. So, giving suggestions for policies and things like that, that's going to avoid maybe accusations of discrimination and things like that. So, avoidance is always going to be better than ending up in a dispute. So, you can say that this is quite a forward looking method. And it can avoid further action. ACAS very useful for employment disputes. Employers often quite keen to use them because they'd rather solve it through conciliation than go into court. And it can be very useful in identifying and clarifying the main issues in the dispute. So sometimes in a dispute, when parties are feeling quite het up and passionate, they might not be seeing the bigger picture. Conciliation can be quite good in identifying they're upset about X, Y, and Z because. So that's quite useful. In terms of disadvantages, it's going to heavily rely on the skills of the conciliator. So if you've got a conciliator that's very experienced, they're obviously going to be able to come up with perhaps more solutions and be more useful to the parties than a less experienced one. Again, like with mediation, your parties have to want to reach a compromise. And again, it's not normally legally binding, which could mean that if you go through all of this process with ACAS, it might still fail and you could end up in court anyway. Okay, so let's move on to our very last type or method of ADR and look at the advantages and disadvantages here. So arbitration then, remember, is the most formal of the ADR methods, and it is where the parties agree to submit their dispute to a party to make a formal decision on it. So it will be very much like a court judgment, but without going to court. And the fact that it's a formally binding decision has a big advantage in that it can be enforced by the courts. So this agreement does have to be stuck to, which is an advantage compared to the other methods. The parties have discretion as to the choice of arbitrator, so they've got some freedom there to do that. And they also have quite a lot of discretion about how the procedure is going to be followed. So they can choose the venue, the date, the number of witnesses. So you've got a lot more power than you have if you're going through the court system. There's rarely any publicity, so although it is binding like a court decision, you're not going to have negative press as you might if it actually went to court. Scott and Avery clauses are there as an advantage because I suppose it's fair. Parties know from the outset what they're agreeing to, that they're agreeing to arbitration. Everyone knows where they stand ahead of the time. And arbitrators will be experts in their particular field. So it will be, hopefully, good advice and good decisions that are being made. Disadvantages are that parties may not be on an equal footing in terms of representation at an arbitration hearing. So an employer is likely to have more money and potentially more representation. You can't get legal aid or help with funding for arbitration, and you can, although limited, for some civil cases. So that's something to bear in mind. There might be unexpected legal points arising that perhaps you would have preferred to have gone to court. Fees can still be expensive here because this is a formal hearing, and there are limited appeals available. And although it is a formally binding process, parties often say that they feel that they didn't get their, quote, day in court. So they don't feel as satisfied, they don't have the closure they think they would have had they gone through the civil courts. Okay, so that's just a very brief outline of the key advantages and disadvantages of each of the methods of ADR.